The petitioner's third witness, Rojo Metununu, was cross-examined by lawyers for the respondents on Monday. They centered mainly on the claims that he had been instructed by the Electoral Commission chairperson to go over and consult with Mr. Mahama, as well as issues relating to some summary sheets that he had certified, some of which he indicated he certified in error.
A functioning mobile phone.
Yes, I had an iPhone that was functioning.
Yes. And indeed, it was the same phone that you allege you used in an attempt to reach the EC chair.
At various times, yes. In some instances, I got her, and at other times, her phone was off.
Now, I'm putting it to you that nowhere in your witness statement do you demonstrate with numbers how your alleged errors in the figures impacted in any material way the final outcome of the 2020 presidential elections. Nowhere.
My Lord, it's not a matter of figures. It's not a matter of figures being put in my witness statements. It has more to do with a trend of anomalies, several anomalies. And we were seeking a forum for a proper presentation of those issues.
Okay.
We were seeking a forum.
Mr. Chikata then informed the court that the petitioner had closed his case and the Electoral Commission was called upon to invite its witnesses, but it informed the court rather that it does not intend to call Jean Mensah, the chairperson who has filed a witness statement, to testify because it believes that no case has been made meriting a response.
If a party who has served a witness statement does not call the witness to give evidence at the trial or put a witness statement in as hearsay evidence, any other party may put that witness statement in as hearsay evidence. So, my lords, we are saying that we are not calling any further witness. If the court decides to treat our witness statement as hearsay evidence, well, the court is entitled to, but we are not leading any further evidence. We are not calling evidence.
Mr. Kotampao supported this particular view and indicated that the second respondent does also not intend to call its witness, but Mr. Chikata disagreed.
We do not intend to call any witness.
Okay, then you prepare.
And my lord, let me complete.
Order.
We do not intend to call any witness because in our view, they have not satisfied the burden of proof. So we can't be forced to call any witness.
It is our respectful submission that counsel for the first respondent does not have it open to him to take the course that he just proposed to this court. Order 36 Rule 4.3 that he refers to specifically says, where the defendant elects not to adduce evidence. In these proceedings, the defendant has put in a witness statement.
Mr. Mohammed's legal team say that the Electoral Commission chairperson is evading cross-examination.
There's not even a claim. They stated clearly that they are not going to call any witnesses, even though they have submitted witness statements. Now, I don't know whether it's evading, running away, whatever, but they are avoiding or running away or evading the cross-examination of Mr. Chikata. We should remember that this is the EC, which has a constitutional duty to the people. They have an obligation to account to us for our stewardship. And they say they are not going to take the witness stand. Well, tomorrow we'll see how our lordships will rule on this.
President Akufo-Addo's lawyers, on the other hand, disagree.
By now, whatever evidence that the petitioner has put before the court, once the case is closed, it is believed that they have brought all their evidence and they have made such a strong case. And so it should actually be to the disadvantage of the respondents if they say that they don't even intend to call witnesses to adduce evidence. But you notice that the petitioners are not too happy about it. They want literally to compel the respondents to bring in witnesses to, I don't know, adduce some evidence that may help the petitioner in his cause. The court has adjourned, as you heard, to tomorrow morning, and we'll listen to the legal arguments on both sides.
Hearing resumes on Tuesday, and the main business of the day will be the legal arguments as to whether or not the respondents, i.e. the Electoral Commission and President Akufo-Addo, whether or not they can opt not to call witnesses onto the stand to be cross-examined in court. Reporting for JoyNews from the Supreme Court, my name is Joseph Akable.
And this is the story so far. Welcome to our conversation this morning. My guests are joining me via Zoom for us to look at what it would be like today. Kojoga, Dr. Opoku-Dusay is a lawyer, member of the NPP communications team. Also joining me is Mr. Kojoga Adaudu, who is also a lawyer and a member of the NDC. Good morning to you both, gentlemen. Thank you so much for making time, as always.
Yeah, good morning.
Dr.
Good
Dusay.
morning, ma'am.
Yes, good morning, Mr. Daudu. Dr. Dusay, can I check if the sound is okay where you are? If you can say good morning.
Hi, good morning.
Okay, great. Mr. Daudu, I want to start with you. First of all, what value does cross-examining the second respondent's witness add to your case? When I say your case, the petitioner's case.
Let me say good morning to your viewers and good morning to everybody, all citizens of Ghana and people all over the world who are eager to see how this petition proceeds. Now, what is the value of cross-examination? Cross-examination has purpose. Now, the purpose of cross-examination is to test the veracity of what the person is saying, also the credibility, and also assist the court to get to the crux of the controversy and settle the matter. So if parties come, we are to cross-examine to bring out whether one, they are telling the truth, two, what they are saying is credible or not credible, and three, it's also assist the court to get to the matter that will assist it to determine the matter. So if we have to cross-examine, these are the reasons why we are going to cross-examine. For the second respondent, we are saying that nobody got the threshold or passed the threshold, the 50 points. And they are saying that they got it by their calculation. Now, the figures they are using are figures that had been posted or have been announced by the first respondent. And once we cross-examine, hello?
Yes, Mr. Daudu, we're following.
Yes. So once we cross-examine, it will bring out the best, and we will be able, for the court will be able to assess and determine the matter. So it is important that cross-examining is done when you come to court, and listen to both parties. And it's also in tandem with the natural rules of law, the natural justice that you listen to both parties. You listen to both parties, that there are two sides to every story, and both sides must be heard.
Yeah, but and I have to stay with you again. So what value specifically would the EC's witness have brought to your case?
If you say the value, the EC's case, you know, the EC has denied. We have come with a petition. In their answer, they've denied a lot of the irregularities. She said she's followed due process. She's followed through the collation right from the polling station to the national. And we are saying, no, that has not been the case. So they have filed an answer to our petition. Now, they've also filed witness statement saying this is what I'm going to say in court. So if we put her to the test, it will bring out the credibility. It will bring out whether it is true, what she's saying is true or not, whether there were irregularities. And if the irregularities were there, does it affect the declaration? So that's what is going to happen if we go through cross-examination with her.
All right. Stay with me, Mr. Daudu. Let me go to your colleague, Dr. Poku Edusei. Are you evading cross-examination? After all, the petitioner put his witnesses there for you to cross-examine. Why can't you do the same? Why are you ending it now?
Good morning. I'm moving a bit, so maybe just about a minute or two, I should be able to settle.
Okay, so let me let you settle. Let me still stay with you, Mr. Daudu. You couldn't get the interrogatories through, the 12 questions that you wanted to put to the EC. That was denied. I'm not sure the status of the facts that you also wanted the EC to admit. I guess that's also a no-show. So
yeah, that was. So it tells you. It tells you that we are seeing some of the lapses in the legal parlance, we'll say lacuna, by the application of the rules. Whilst the application of the rules is being done, like it stated, the Supreme Court still has the power of a High Court. That is why the High Court rules are used as in complement to the rules of the Supreme Court. Now, it is, whilst the interrogatories were being asked, I think you could hear from the court itself that those questions can be asked in cross-examination. So even if we deny you, does not mean that there is a part that those questions cannot be asked in cross-examination. Two, if you watch, the rules of the High Court were being applied. It gets to a point, the court says that we will not apply this specific rule for few reasons. Now, they are also relying on the High Court rule. So it is becoming like we want to choose which rule to apply and we will not apply the other rule. Because when you look at the request to admit, it is the High Court rule that is being used. Now, it must be seen, and when justice is being done, it must be manifestly done for people to see. Do you apply one of the rules in the same rule book, and another time you say, I will not? Now, the essential of this is that if you look at their witness statement, which they are saying at the material moment is not evidence, is as a result of the lapses that we are having in CI 87, which says that there should be pre-trial case management conference, and this has been done. So you would find out that there are lapses when it comes to the High Court rules and the CI 78, what it says. At the same court, once it was not even admitted as evidence, the witness statement, in cross-examining the witnesses for the petitioner, the court, they applied, and court also allowed them to use some of their exhibits to cross-examine the petitioner's witness when in actual fact it has not been an evidence, but the court said you can use those documents. When it comes to the time, we will admit them as evidence. But for now, you can identify it and use it. That's where they said if it was an issue of oral evidence, he was saying, can't you tender the document through him? So you get to see that there are lapses when it comes to the CI 87, which has brought the pre-trial or the case management regime and the High Court rules. And the application of it is not smooth, it's not even as it is now because of the lapses. So you realize that when the questions that have been asked request to admit interrogatory speech, the court itself says that you can ask these ones in cross-examination. And now the first respondent says that I will not go through cross-examination because I'm using the rules within the High Court rules to say that it gives me a power to exercise or a right to exercise. I'm exercising this, so I will not do it. I think that was where the issue of Order 36, is it a precondition as to, or it had to be done before the pre-trial conference management? And this is where we have issues with, or in the legal balance, we say there is a lacuna and the law must be seen to be harmonized, to see the way forward. Because it's brought up lapses in our practice with the witness statement and what it is going on.
Okay, let me come to you, Dr. Dusa, and I really do hope that you've settled now. If you have, in 2012, 2013, you didn't face these hurdles. You had your interrogatories, all right, the questions were put through. You didn't have issues with witnesses from the other side not testifying. I want you to forget for a minute that you're a member of the NPP's communications team and just talk to me as a lawyer. And we're not talking about the decision that the court will make later this morning. Just the issues in terms of the interrogatories not through, admission of facts, that also didn't go through. And this issue is hanging. That must be disappointing, just talking to you as a lawyer, wouldn't it?
Well, it is not new because anytime you are going to court, it tells you that as the person who is starting his case first, you must ensure that you put in sufficient evidence, said that on the issue in contention, the court will have no conclusion to reach than to rule in your favor. So if in coming to court, your argument basically was that no candidate in the 2020 elections obtained more than 50% votes nationwide, it tells you that you had the burden of establishing that these are the numbers, and when you put the numbers together, President Akufo-Addo got 49.8%. I got 48.1%. Without that kind of figures, it means that you have not met that minimum threshold under Section 14 and 17 of the Evidence Act.
Oh, unfortunately, we've lost the connection there. Dr. Dusa, okay, but we can hear you now, so if you can continue.
Yes, so if you don't meet that minimum threshold, it means that the other person will then going to exploit that and use a strategy which is permitted in the law.
Yeah, but who determines that you haven't met the minimum threshold? I mean, this case has been on course, hasn't it?
Well, as part of the determination as to whether the respondents can decide to avoid calling their witness, that issue can be determined. Because the foundation of it is that if in the totality of the evidence which has been given in court so far, you'll not be able to prove that none of the parties got 50%. But it's now that you are waiting for the other person to mount the witness box so that you then start pontificating over figures, then it means that there is something lacking in the case you put up in the first place. And that is what they're actually taking advantage of. And it is actually known in our civil procedure. If it wasn't known, there's no way they can ground it on the CI 87 and then CI 47 as they did. So it means that having cited the CI 87, which gives the consequence of they taking that kind of step, it will be that the witness they are going to call, or they intimated they were going to call, they will then have their testimony, which was supposed to be the witness statement, expunged from the records. Or if the petitioners are minded, they can then decide to treat it as hearsay evidence. Those are the two consequences in the law that we have. So it is about strategy. They have seen what has been put together so far. They have cross-examined the petitioners' witnesses on it. And they realize that either the witness said, we are not the one to answer this question because we are not the petitioner, and that's the case of President Katia, or the others basically came and gave some account that happened in the strong room, which actually doesn't go to the grounds of the 38,611 polling stations nationwide, plus the special votes. So that way, they think that there's nothing undermining their case, and they are taking that risk of putting every matter before the court to say that decide the matter at this point. And if they are successful, the case will then come to an end for the court to then decide to assess whether there should be addresses going forward.
Mr. Daudu, I want us to talk so that the ordinary person watching can understand where we are. So you say I have stolen, and I say I haven't stolen. But you've gone to court, you have your evidence. And I say that I don't want to say anything beyond what I have written in terms of the response. I don't want to put myself out there so that I can answer your question. What is your business? Can't you move your case forward with that?
Let me see. There are two different scenarios here. The scenario you've presented is about individuals, right? Two individuals. Now, the scenario here is that we are not in the High Court. These are High Court rules. And this is a petition. It's a specially crafted jurisdiction that will go to the court, and it has its own procedure by which you go to court. And this is the Supreme Court, the apex court of the land. Now, with the performance of a duty which has been imposed on a public institution, where we know that all public documents are stored, and we are talking about the performance of a duty that has been imposed, and nobody can perform that. So it is about the office. It's about the institution. It's not about the person who occupies that office. It is about the office. Now, if we treat it as is an individual, then it's going to set a dangerous precedent that people in public office can decide to do anything in the performance of their duty. And if they perform their duty and you take them anywhere, it takes a posture that I'm not going to speak. I won't say anything. You have made this allegation, so I won't say anything. When we have entrusted, or the public has entrusted that duty in your hands, what is going to happen? Because it will be a precedent that every person who occupies a public office will now tell you, and it's going to be very dangerous. We are witnesses to where you even ask public institution, and this same electoral commission will ask for some documents. A court, a superior court, has asked that gives this document. The public institution and the officers say, I won't give the document, I won't give the information. And if that is the trend that goes on, everybody in a public office will say that even if the court compels me, I won't do it. And is that the precedent that we are saying? So it is not just like about two individuals. It's an issue of public policy. It's an issue of public interest. The public wants to know our document, the duty that has been imposed on you, whether it was done perfectly, competently, effectively, or it was not done.
Okay. Well,
this is the crux of the matter.
Okay.
So if we take it that it's like a case between two individuals, it is not about the person that we are talking about. It's about the office. It's about the returning officer of the presidential election, whether there was that performance of duty was done effectively and efficiently.
Okay.
And we are saying that that was not done properly.
Okay.
So you can't come and say that I've been imposed with public duty and I won't say anything.
Okay.
Then it means also that the president one day can say that the public has imposed duty on me. I won't do it. If you ask me a question, I won't say anything about it. So it would run down, it will cascade down to all public institutions. And where shall we be going with our democracy? Those are the crux of the matter.
Okay, Mr. Daudu, fortunately, the forum where you are is also a forum for public policy. So let's wait to see the decision that they would arrive at. But let me move on to Dr. Dusay. Dr. Dusay, look beyond your immediate members who will probably be happy with the strategy that you've put up in terms of supporting the EC in this matter. And you also saying you won't put up your witness to be cross-examined. If you look beyond your immediate supporters, you realize that very ordinary people are disappointed by this decision because to them, the Electoral Commission chair, the returning officer in the presidential elections would have settled the score. What do you say?
Well, before I answer, I wouldn't agree that the public will be satisfied. Not at all. But just 2 quick points. I believe that the essence of this entire petition was basically to discredit the chair of the Electoral Commission and also basically bastardize her. So if that was the route they were looking for, I don't think that the Supreme Court, by way of an election petition, was the right thing to do. If they also wanted an accountability, it is not through election petition per se that you can ensure that public institutions are accountable. So they should not think of evidence that can be procured and all those, because one of the key mechanisms for ensuring accountability in public offices is the use of judicial review processes. And normally that's done in the High Court, whether you are asking for a mandamus in order to compel the public officer to act, a prohibition in order to restrain them, and all the other available judicial review mechanisms, such as certiorari, to quash something they have done. So if that is what they went to court for, accountability, public policy considerations, then my bet to them was that they shouldn't have gone through an election petition. When you go through an election petition processes, then you are met with the rules that are permitted in election petition matters for you to attend to. So that's the challenge they are having now. It is not about just a public policy suit. It is an action based on an election petition challenging the validity of the elections. But if you go and you say that our essence is not the validity of the elections we are challenging, but we are challenging the conduct of the officer, then it is as if you came with a judicial review application shrouded in the character and clothing of an election petition, and that is not permissible. That is where they are having those challenges.
You wanted to address the second. Mr. Daudu, just before you come in, there was a second leg to my question. It was a double, actually, Dr. Dusay. How about the ordinary people who thought that Jin Mensah in the witness box would have brought closure to this matter?
Well, when we set up the entire judiciary, we gave them certain powers that the sovereignty of Ghana, even though it resides in us, they are the body responsible for adjudication of disagreements. And once we have given them that authority and they have the backing of the state powers, anytime they hand down decisions, the people should understand that that is actually the position of the law that Ghanaians have elected to be with. So now the position of the law is that you just don't rush to the Supreme Court for election petition when you can seek for other means of public accountability through Parliament, through judicial review processes, and go to the Supreme Court and say that I'm challenging the validity of the elections. election is a serious business.
Yeah, but those processes, Dr. Dusay, cannot overturn an election results.
I can't hear you. I didn't hear the question.
I'm just saying that would those processes that you outline overturn an election results?
But you know, what they are in court for is not to overturn the election results. They are actually to challenge the conduct and the performance of the electoral commissioner, in this case, the chair of the commission, in terms of her public office duties. That's all that they are in court for.
And also to get the court to say that nobody met the threshold required.
The threshold in terms of challenging the validity of the elections?
In terms of what you need to actually be declared as winner of a presidential election. And what would that mean if we came to that conclusion?
So, that threshold is that someone should have obtained over 50% of the votes. And the gazetted document on the 9th, on the 12th of December, clearly states that the president now got more than 50% of the votes. So that's all that the Electoral Commission is supposed to show. But they want to go into the numbers that were put out on the 9th, on the 10th, in terms of their press releases. And I'm saying that that doesn't go to the core of the voting and counting, as well as the collation that took place in 38,611 polling stations nationwide, constituency region. So if it doesn't go to that core, it means that you have not made a case, because when you came, you said that no one crossed 50%. You should have then tabulated that in Ayesuano, the numbers were 39,000, but you realize that they are counted with 40,000. In Kumewu, the numbers were this, they are counted with this. When you're able to give those numbers, then the respondents will have no other option than to call a witness to come and actually give his version. Other than that, it means that there's no other version than what has already been put out there.
Okay,
that's where the challenge.
Mr. Daudu, you wanted to react?
Yes. Let me quickly say that whilst we are in court, our case is the constitutionality of the declaration. That is one of the cases. We are not in court because of accountability. No. We are not in court about the figures. The figures they are using Electoral Commission, it's saying, is the figures that the Electoral Commission on her own brought. And we are saying that that figure is unacceptable. And they are insisting that that figures that was announced or declared by the Electoral Commission is the actual figures. So we are talking about the constitutionality of the declaration. What culminated in the declaration, in that an instrument was prepared and has been gazetted. And we are saying that the whole process by which you've gone to arrive at that, it is not right, it violates the Constitution. This is what we have put. Now, you could also see, you asked about the ordinary people. How would they feel? Yes, the law is a double-edged sword. It can be used for good, it can be used for evil. That's why the law says that, yes, it's a double-edged sword. You are saying that you are using a strategy. And we are saying that whilst there was pre-trial, you could have elected and given the indication. We have gone on, you've used your S-bits, which you were prepared and were not evidence, to cross-examine when it was not accepted. So for me, the Ghanaian and the populace watching the proceedings and what is going on will be the best judge to say that the rules are being applied evenly, justice is being done, and we said that when justice is being done, it must manifestly show that it is being done. I'm sure the ordinary Ghanaian on the trotro from Circle to Accra, what he thinks and would think that the court is doing and how the law is being applied is even, and it is on a scale. That is why when the court is exercising its discretion, it makes sure that that discretion that is being exercised is fair to everybody, it is candid, and that is it. So, yes, the law, and I've always said that it is a very good judge who can abuse the process by understanding the law and twist it how he wants it. So I think that the question you asked, that the ordinary Ghanaians, they are watching, I think all over, they may have their own perception as what is going on in the court by what they watch, their understanding. And I think that that is why, if you read our constitution, it says that the power or the judicial power, that power was given by constitution belongs to the people. And that power, judicial power, has been given to the judiciary to exercise. So I'm sure at the end of the day, it is what the people see, what the people feel, and justice, whether it's been done manifestly for them to see, they will be the best judge.
Okay.
Let me also go on and say that.
Yeah, go ahead.
If you look at the figures we are talking about, the figures they are talking about, we have given samples where they have been wrong, or 2 or 3 different collations from Eastern region, Northern region. We have given. If we were in court about the figures, we would have brought all the figures and tell them that these are the figures. But we are saying that the process you even went through and the irregularities, and this is the one that we are saying that was culminated in the declaration, violates Article 63. And I think that they are shifting the goals, always saying that it is about to bastardize the EC. And what would it be if the EC is able to just comply or go for everybody to see that, yes, I have done my work, I did it competently, I did it efficiently, and like they have answered in their answer, that yes, I went through due process in accordance with the law. So that's the issue.
Yeah, I just also wanted to add that ordinary persons may not understand what happens in the courtroom. You are learned people, and that's why we bring you on, so that we can break some of the issues down, so that it doesn't just come down to how they understand what's happening in the court, but, you know, we also give them some bit of education to better their understanding. Dr. Edusei, we want to bring the conversation to a close. Help us understand how you're playing this game going forward, because you've made us understand many times that this is a strategy for you. So you would still insist that Peter McMahon will not be in the witness box, correct?
Yes, that's our position. And today we'll advance legal arguments to support that position. That when they were coming, they said that the results, as declared by ECE, wasn't acceptable. But they should have come with some benchmarks for us to compare what they have, and they have failed to do that. Having failed to discharge that burden, we believe that it is not fair to Ghanaians for them to be taken through this when we have serious issues of government and governance in this country to go through. And for that reason, you cannot just appeal to the people in terms of appealing to their pities, that I call the argumentum ad misericordium, and then not provide any evidence. If you just want to appeal to the masses, it is not in the courtroom that you go and appeal to the masses. That is propaganda you do. Yeah, but
that conclusion, Dr. Edusei, that's your own conclusion. That's not what the court has said.
No, that is actually Mr. Dawudu's conclusion. That people of Ghana are watching, and that whatever is going on, they are the ones, best judges and the rest. If you want to appeal to Ghanaians generally, you don't go to the courtroom without evidence to run your propaganda. You go to them and organize press conferences, be on radio and articulate your propaganda so that it will also be responded to accordingly. But when are
you denying the facts, Dr. Edusei, that Ghanaians are watching and will also make their own interpretation of what's happening?
No, I was only commenting on their appeal to pity and the masses. And I'm saying that there's a forum for that. They want EC to be accountable. There's a forum, another forum that they can use to ensure that they get whatever information they want to get from the Electoral Commission. Okay. But when you are going to challenge the validity of the elections pursuant to Article 63 of the Constitution, you must be armed with evidence.
Okay, great. Mr. Daudu, I'll give you the last say, but we established here in one of our conversations, I think one of our earlier conversations, that We're not saying the court has not established that you need figures to challenge the validity of an election. Can we be clear on that, Dr. Dusay?
Mama V, I think that in the first place, before I finish, my colleague on the other side has not been fair to me if I say by his conclusion being very judgmental. I said posterity or the Ghanaian populace are the best judge. It doesn't mean that because you ask a specific question about how do the ordinary people understand. And that is what I said. But if to allude that that is my conclusion, I think that it's not been fair to me on that point. Now, we would expect, or we will go and make our arguments today, whilst we put forth a legal argument and the courts would look at it. That is what we would think that the court would decide. And if the court decides, when we get to the bridge that the court itself said they will provide, we will cross the bridge. Now, about the figures, I think that what the understanding of the case we took, and the court was saying that what are the figures? The figures we have now, and we have said that there are 2-3 different figures by the Electoral Commission, and they themselves have admitted that there were errors. So if they have admitted that there were errors, what figures do we now deal with? What is the valid figure that we can have and deal with? And that's all we are saying. And their case is that we should have brought figures and others. Now you are asking we should have brought figures and others, and you are saying that you are not going to mount the witness box. Fair enough, it's a legal strategy. Whether it's being done in good faith or it's being done in bad faith, it's for posterity to judge.
All right, gentlemen, we will follow up on how things go today and come back to you again. But as always, we're grateful. Dr. Poku Adesei is a lawyer, member of the NPP's communications team. And as you heard there, Kojoga Adawudu is also a lawyer, and he's a member of Mr. Mahama's legal team. All the best in court today, gentlemen.